Thank you, Matt. I'm turning now to ground 2, which is supply pass-on.
Yes.
I'll structure my submissions as follows. Firstly, I'll make some high-level points by way of introduction. Secondly, I'll address the requirement of causation in both law and in fact. Thirdly, I'll address the supposed error of law and explain why there was no such error.
Yes.
And fourthly, I will go to the reasoning of the majority on the facts and deal with the specific criticisms that Mr. Beard made. So by way of introduction, the supply pass-on case was at best strikingly ambitious. The argument is that the overcharge on trucks caused prices of products such as stamps or telephone line rental to be higher. And of course, DAF's case was there was no overcharge at all. So from its point of view, pass-on was purely hypothetical. So the argument is only if there was an overcharge, then the respondents would have passed it on. So of course, it doesn't allege any concrete measures whereby the overcharge was noticed by the management and prices were adjusted accordingly. But undeterred by that, their case was that between 75 and 139% of any overcharge would have been passed on by Royal Mail, and just 100% for BT. Now, the reason why the case failed was not simply because of the relative size of the overcharge compared to BT and Royal Mail Group's revenues, but that was undoubtedly a factor. And as you would have seen from the judgment, on Mr. Harvey's overcharge figure, the overcharge never exceeded 0.05% of Royal Mail Group's revenues, or 0.003% of open reaches, the one division of BT that DAF focused on. And those figures, of course, were on Mr. Harvey's view of the overcharge of something like 10%. So if we roughly halve those, we're talking about 0.025 and 0.0015%. Now, to make matters worse, both Royal Mail and BT, of course, sell a myriad of products, and some, like stamps, are very low value and sold in vast quantities. So Mr. Harvey's analysis was that if the entire overcharge had been applied to the price of a stamp, it would have increased it by 0.014 pence, or if you like, 0.007. Well, and again, needless to say, each respondent had very complex internal cost allocation methodologies. And they're explained in the judgment. I won't take you to it, but for Royal Mail, it's 576 to 583, and for BT, it's 639 to 641. Yet, according to DAF, it could not only trace that tiny amount through to the price of the individual products, but it could show that this tiny cost increment actually caused a price increase. Now, the majority, of course, found that was not the case, but Mr. Beard says the majority erred in law. But a very important starting point is that the CAT was unanimous in its approach to the law. There is a whole section on this which you haven't yet seen, but I will take you through. But we can see Mr. Ridyard's confirmation that he agreed with it at page, perhaps just for your note, page 398, paragraph 702, in our unanimous discussion of the legal principles. So that's quite important, and that section of the judgment is very important. And it discloses no error at all in our submission. Well, as to the facts, there were about 2,000 pages of expert evidence on this topic, numerous regulatory documents, pricing papers and the like. But it is striking that DAF has chosen to put not one single page of that material before the Court of Appeal. There is nothing in the supplementary bundle at all. So in our submission, the appeal is largely just a dispute about the evaluative judgments made by the CAT on the material, and the DAF's arguments fall very far short of the required irrationality threshold. Now, Mr. Ridyard reached a different judgment on that material to the majority, but that, of course, does not establish that the majority's judgment was itself irrational.
It simply establishes, doesn't it, that two people could reach a perfectly reasonable but opposite conclusion about something.
Indeed, indeed. In fact, we'll show why, in our very respectful submission, we think Mr. Ridley's dissenting judgment is wrong, but it doesn't matter at all. Simply doesn't matter. And if the tribunal's finding on the facts is rational, the majority's, then it simply doesn't matter if it erred in law. Now, Mr. Beard recognised that problem because he sought to argue that the legal error coloured, I'm sorry to use his word, the majority's factual analysis. But that's not right, and the argument was based on a highly selective reading of the majority's judgment. Now, it's also worth bearing in mind how opportunistic this aspect of the appeal is. More than 6 years has passed now since the decision was published, and as far as we know, DAF faces no downstream claims from disgruntled stamp buyers. And even Mr. Ridyard thought the claims would be impossible to quantify. So these arguments are not actually about the correct allocation of compensation into the value chain. They're raised in order to defeat compensation altogether.
Yeah.
Now, before turning to the substance, I also want to say a little bit more about the taxonomy of the issues. If DAF is unable to show the majority's sorry, I've already made this point. I want to just talk about the scope. The scope. DAF purported to run the supply pass-on case against the full range of the claimant's products, regulated and unregulated. And that picture is very complex because there are a large number of different products and different business units within each of the respondent entities. And in some cases, there is internal pass-on before there could be any question of overcharge reaching end customers. For BT, there were numerous different regulatory instruments of different kinds on different products. And for both respondents, there were unregulated products. So what DAF did in practice was focus on a subset of those arrangements, and this appeal is even narrower, as you've seen. For Royal Mail, it's PC2 and PC3, which I'm going to come to. And for BT, it's the RPI minus X price controls applied to OpenReach. Now, as I'm sure the tribunal knows, the court knows, OpenReach is the wholesale provider of telecom services, both to BT itself and to third parties such as, for example, Sky. And OpenReach has a number of different price control instruments, and RPI-X, which is the kind in issue here, covers just 55% of its products. And that, for your note, is in the judgment at page 380, paragraph 647. And even when one looks at OpenReach, there is then internal pass-on within BT, because OpenReach supplies BT Retail, for example, and other BT divisions. So in that sense, this appeal is very partial, but it also raises a further scope question, which is about how much overcharge is being said to be passed on. DAF skeleton refers to at least some overcharge, and that's page C6, page 74, paragraph 73. But Mr. Ridyard, whose dissent they rely on, said it was empirically hopeless to quantify it at paragraph 705 and virtually impossible at 7384. But even the narrow points they do make are without merit for the reasons I'm now going to turn to. And that takes me to my second head, which is about causation in law and fact.
Yeah.
And I want to start with something which I believe to be common ground. DAF needed to show that Royal Mail and BT's prices were actually higher because of the overcharge than would otherwise be the case. That it's a but-for test. It's a very basic proposition that is important to keep in sight. And we think that's accepted in their skeleton argument at paragraph 83. And if there were any doubt about it, it's clear from the Sainsbury's case in the Supreme Court at paragraph 205. In fact, the actual formulation of class 4 pass-on is the merchant can pass on the costs by increasing the prices which it charges. So there has to be causation. And that's why mere cost recovery is not enough. So if we suppose a firm has costs of £90 and sells its product for £100, it's then the victim of a cartel and suffers an overcharge of £1 on an input, so its costs rise to £91. Well, if its price stays at £100, it's recovered its costs, but it hasn't passed on the overcharge. And this is recognised by the majority. I'd like to show you this part of the reasoning. It's at page 359, paragraph 564.
Yeah, 564.
359, paragraph 564. Looking at the notion of cost recovery in a bit more detail, this seemed to underpin much of Mr. Bazant's analysis, particularly in relation to unregulated periods. All businesses seek to recover their costs and make a profit, but in itself that tells you nothing about whether a price increase has been caused by an increase in costs.
But it's really a sort of, I mean, in a sense, it's the same point, isn't it, as the reason why the loss is measured in terms of the overcharge rather than, for example, in relation to the loss of profits.
Absolutely.
Is because there isn't a loss of profits, because obviously any well-run business will continue making a profit, albeit less of a profit, as you showed in your example.
Unless it passed it on and the burden is on the defendant to show that.
Yeah.
Absolutely. And you'll see that the tribunal continues with this point.
Yeah.
Mr. Bazant said he still thought cost recovery was informative. He relied on various scatter plots, which he said illustrate the relationship between costs and prices. However, a relationship does not mean that a very small increase in one particular cost input would inevitably lead to a price rise. That is exactly what is in issue. And to foreshadow a submission I'll get onto fairly shortly, there's no confusion in the tribunal's mind about the test, the counterfactual it needs to be assessing against. It's just asking the question, are prices higher because of the overcharge? Now, staying with the judgment, it's important to appreciate that this is, we think, common ground, and certainly was at an earlier stage of the proceedings. May I ask you please to turn to page 237.
These are the passages from the judgment of the CAT at an earlier stage.
They are. This is the so-called May 2021 judgment,
Yes.
where the CAT faced an application like the one that my Lord and Lord Justice Green considered in Stellantis.
Yes.
And just to pick up paragraph 204 that quotes, and I will, I'm afraid, be going back to this in greater detail. There's a quotation from the judgment of Mr. Justice Roth, and the last 4 lines of it, which are underlined by the tribunal. As DAF accepts, the general principle that all costs of inputs are fed into business planning is insufficient to establish the necessary causative connection for a plea of mitigation and loss. And then you'll see the tribunal goes to your Lordship's judgments in Stellantis, and quoting from Lord Justice Green's judgment, pulling the strands together, the burden of proof when pleading causation is on the defendant to demonstrate there is a legal and proximate causal connection. And then at the bottom of that paragraph, not emphasised by the tribunal but emphasised by me, is the final sentence. It may be easier to show a pleadable case of mitigation in some circumstances than in others. Now, of course, Stellantis was a so-called Type 3 case in Supreme Court classification. But what I will show you is that the tribunal treated Type 3 and Type 4 together, making the correct observation that the Supreme Court did as well. And that has never been challenged by the DAF in this appeal, not in the notice of appeal and not in its skeleton argument, even though there were some murmurings to that effect yesterday. And there's no doubt that the facts surrounding Type 3 and Type 4 are different, but the legal test is the same. Now, DAF's argument, the so-called point of principle, is that the Supreme Court in Sainsbury's effectively stripped this requirement of legal causation of any content, that it reduced it to bare factual causation. But the short answer, which I will develop, is that the tribunal carefully considered the law and followed this court in Stellantis. In its approach to the Supreme Court's observations, the Supreme Court was dealing with a transparent and well-known charge that was applied to every transaction processed by the claimants, and that is fundamentally different from the secret and in relative terms tiny sums at issue in this case.
Why does secrecy have anything to do with it?
Secrecy matters, not because of the overcharge, but the issue isn't whether the cartel is secret. Cartel will always be secret. The distinction is between what my Lord Justice Green called a known and troublesome charge in the form of a MIF, where the industry sits there and says, well, we've got to do something with this MIF. What are we going to do? We don't like paying it. We wish we weren't charged it. We're going to stick it on our customers. That's one thing. It's another thing when you have a cost stack of £17 billion, like Royal Mail, and in there somewhere you have an item for vehicles, and within vehicles somewhere there is some trucks, and within the trucks somewhere, unbeknownst to you, is a tiny amount of overcharge in relative terms. So because you don't know anything about this, the business is not in a position to sit there and say, what are we going to do about this? Perhaps our customers should pay.
But I don't follow this bit. What surely matters is that the buyer knows the price. That's what it will or won't.
The buyer of the
react to.
truck in this scenario.
In this scenario.
Yeah.
What it will or won't react to, what it will or won't pass on, is the cost it incurs in buying the product, buying the truck. It really doesn't matter whether there's an overcharge or whatever. It will know the price it's paying.
It knows the price it's paying. But
That's not secret.
No,
I think
no,
I think in Stellantis the issue was perhaps slightly different. It was a pleading point because the defendant had pleaded that the claimant would have taken steps to mitigate, and that would have presupposed knowledge that there was an overcharge. Whereas if it was secret, you couldn't say they would have because it required sentience. And that, I think, was the gist of the point there.
My lord, I accept that entirely. And that's why it's very important to put this secrecy point into context. It is one of the so-called 4 factors which the tribunal regarded as non-exhaustive. It considered they were indicia and it looked at them cumulatively. And then when it had done that, it said, and now let's look at the evidence beyond that. I'm not before your lordship saying secrecy is the answer. But the question for Mr. Beard is a rather more difficult one, which is it so legally irrelevant that the tribunal, even alluding to it, makes the decision wrong in law?
And I follow that point, and I also follow the potential significance of the size of what we're talking about, but that's different from the secrecy.
So if I can try again, my lord, the question we're looking at here is what is different as between the factual and the counterfactual? And the difference between the two is this, to use the cat's word, tiny amount of overcharge. And if this tiny amount of overcharge is completely unknown, unlike the troublesome charge in MIF, then the likelihood of the business having done something differently because of it is reduced. As my lord says, they will seek to recover the cost prices, the trucks. The trucks are in the cost stack no matter what. But when the price of the stamp is 57 pence, say, the question is, entirely oblivious of this inflated charge, will that 57 pence stamp become 58 pence? And the point the tribunal is making is, when answering that question, it is at least relevant that you simply don't even know there is that inflated element of 0.0007 pence.
In Sainsbury's, it's my recollection, I haven't reread our judgment in the Court of Appeal, but my recollection is that the pass-on defence failed in Sainsbury's.
It did.
It had failed in the CAT, or it failed, I think it was in the CAT.
It failed in the CAT.
It was only the CAT that dealt with it, I think. Because, amongst other things, it was said that the whole system of costing was so complex that it was impossible to say, even though they knew about the myth,
Yes.
that they'd actually taken account of it by passing the cost of it on to their customers.
Indeed.
And in a sense, in the Sainsbury's context, if the myth had been secret, there'd have been even less scope for saying, well, it's been passed on through a complex system of costing.
Yes, and of course the only difference here is that Sainsbury's is unregulated price setting, and Mr. Beard says that it's the regulation that makes all the difference.
Yeah.
And we will come to that later this afternoon, if I may.
Well, it must be of some relevance, maybe not as much relevance as the tribunal thought.
Well,
But as you rightly say, it wasn't as if it was the be all and end all of their reasoning.
Indeed, and if Mr. Beard's case comes down to a debate about the weight attached to each of the four factors, then in my respectful submission, he's bound to fail. I was going to say something about the policy. Sorry,
I don't know if you're going to come back to this or not, but in the context of the Sainsbury's in the Supreme Court, that sentence that deals with legal causation, but the question of legal causation is straightforward in the context of retail business, etc. Is that simply, do you submit, that's simply the Supreme Court's way of expressing the British Westinghouse test? Because you need to show, I mean, in a contractual context, you need to show that whatever it is that the claimant, the victim, has done arises out of the transaction. Here you have to show that causative connection, and the point they're making is no more than, well, in a case like Sainsbury's, it's perfectly obvious, precisely because a retailer will pass on, a retailer will take account of its costs in its business planning. So you can't say, well, whatever it was that Sainsbury's did had no connection whatsoever.
Yes.
No causative connection whatsoever.
Yes,
all of us are puzzled as to
Yes,
what the differences between legal and factual causation.
Well, I was heartened yesterday to hear my lord say that he found it puzzling, as I've certainly spent plenty of time puzzling over it myself. But the answer is, undoubtedly in Sainsbury's, what is happening is the Supreme Court is applying the British Westinghouse test. It emphasises it in the original emphasis.
Yes.
We are going to come to that, I assure you.
Yeah, I'm sure. That's
and my
fine.
submission is going to be that the tribunal took a lawful and rational approach in the way it applied the Sainsbury's judgment on the facts of this case, which were very different. And I was going to, if I may, say something about the policy reasons for the British Westinghouse rule as applied in this context.
Yeah.
Now, of course, it's a rule of a long-established rule of the law, and I'm going to nevertheless express the policy for it in entirely modern terms of proportionality and effectiveness. Because what the rule does is it ensures that highly remote and convoluted arguments based on causation cannot serve to defeat a direct purchaser claim. Because, of course, the more convoluted they are, the less likely there is to be any indirect purchaser to bring a claim. And primarily, the rule about pass-on is about compensation allocation down the value chain. And indeed, the damages directive makes that very clear. Now, of course, DAF is right that damages are compensatory and not punitive in this jurisdiction. But on the majority's findings, there was no question of overcompensation. And the tribunal is very clear and explicit about that in paragraph 690. They say they don't think the claimants are being overcompensated. But I acknowledge, of course, the law strives to avoid double recovery against a wrongdoer such as DAF. But in the absence of any downstream claims, the defence is really not a bulwark against double recovery, just an attempt to frustrate the claims that have actually been brought. So it's through that lens that one should see the requirement of close proximate causation.
Well, I'm not sure why. I mean, British Westinghouse had nothing to do with that. So if you're saying, well, this is an application of British Westinghouse, well, why should the possibility of an alternative claimant bear on it?
Well, it gives a compelling logic in my submission for the rule having real meaning in this context.
What do you say the rule is?
Well, that there must be close proximate causation, to use the court's language of Stellantis.
Well, if we have British Westinghouse in mind,
Yes.
you exclude things where there are breaks in the chain of causation possibly, or things where you treat them as unconnected, sort of res inter alios acta or whatever.
Insurance contracts.
Insurance contracts. That's all fine, but doesn't seem to have anything to do with the availability of an alternative claimant.
No, indeed. Of course, I started by acknowledging the fact that the rule obviously greatly predates this competition law damages regime, which largely flows from the judgment in Claridge and Crean that we were talking about this morning. So, of course, that's right. But in this context, the logic of it is compelling. Mr. Beard's submissions are effectively it should be stripped of any meaning, and that any form of bare causation would suffice.
Can I just test it a moment longer?
Of course.
So suppose you have a situation where there is an overcharge of whatever size. The fact that it's very small might make this less probable, but suppose you have an overcharge of whatever size where the purchaser does indeed do things to raise its prices, with the result that customers mitigate the effect of the overcharge. If that's established factually, why should there be some other limitation on the claim?
Well, the answer to that, my lord, is partly the question of proportionality, because your high-level example, if I may say with the greatest of respect, begs the question about how tendentious and complicated and difficult to prove this line of causation really is. And this case actually illustrates the point perfectly, that there were 2,000 pages of evidence. Mr. Bazant is a forensic accountant. Using forensic accountancy techniques, he sought to trace this tiny amount of money through all of these stages at enormous expense and ultimately failed. So the reason I invoke those modern concepts of proportionality and effectiveness is I would respectfully submit that certainly in this context, that is in fact an unsatisfactory way to go about things. Now in your lordship's stylised example, or if it were very simple, a retailer says, here is a troublesome charge, all my rivals are facing it, well, I'm going to pass it on to the customers.
Well, this
That's
is
perfectly
I
straightforward.
think, the point, isn't it? I mean, if we look at Sainsbury's, not at Sainsbury's itself, but at the myth,
Yes.
everybody knows about it. So you know you've got this myth that you're having to pay to your bank, and you think, well, I'm not going to just swallow that. I'm going to pass it on to my customers. And let's say, for the sake of argument, there is correspondence, internal correspondence that says that the cost is passed on to the customers. That would establish, would it not? That in itself would be sufficient
It
to
would be.
establish a pass on,
It would be straightforward.
irrespective of whether or not those customers are going to make claims against Visa and MasterCard. That's neither here nor there.
I completely accept that. That is the example that would be straightforward in the language of the Supreme Court. It's just that we are at the absolute other end of the spectrum.
No, I follow that. But I think what my lord and I are both saying is that the reason why we're at the other end of the spectrum doesn't seem to me, at least, and I think my lord is saying the same thing, to depend upon whether or not there are other people out there who might make indirect claims.
I have the luxury in my argument of not needing to press that point.
And I quite follow all the things that you say bear on factual causation.
Yes.
But suppose you can establish factual causation. You say, well, even so, you have to worry about considerations of proportionality and complication and whatever. So what's the dividing line? At what point, when does establishing factual causation become so complicated that you say, no, you can't do it?
Well, I'm afraid I'm going to say something I said once too often this morning already, which is that is the question for the evaluative judgment of the tribunal.
And what principle should they apply?
They should apply the British Westinghouse principle as explained by this court in Stellantis and ask themselves whether there is a close and a legal and proximate causal connection. And the word proximate has relevant legal content. And my lord, Mr. Justice Roth, used the word legally causally connected to the overcharge in the direct manner as required by British Westinghouse. And that's, if it's helpful to see that, that's in the judgment at page 236, in paragraph 36 of the May 2021 judgment. And you can see that in the last line of the quotation from paragraph 36. The steps taken were triggered by, or at least causally connected to the overcharge in a direct manner.
Just apply that to the context of this case. So suppose, for the sake of argument, Mr. Ridyard were right, and you could see that the increase in the cost of trucks had fed through to an increase somewhere in the prices that Royal Mail was allowed to charge and did charge. Is that a direct effect?
Well, we would say not. No doubt Mr. Beard would say it was.
what's the distinction then? Where's the dividing line between the direct and the indirect effect?
It's a fact-sensitive question, my lord, because in this case, what you have, quite literally, is the purchase of trucks by BT. Those trucks being used for various ancillary activities within its network, as everyone's familiar with the sight of them on the street. I think, in fact, a lot of those are vans, I should say, but doesn't matter. The point is still the same. Meanwhile, BT is engaged in the business of selling people wholesale and resale telecoms operations of various kind. Within BT somewhere is an enormously complicated cost allocation system and a way of recharging various costs to various divisions. And in the course of that, all kinds of assumptions are made, such as cost allocation methodologies and the like. So there is just a vast quantity of information in there within BT, and that's even before it gets into the hands of the regulator. The regulator then sets a plethora of different charge controls. Some are RPIX, some are caps, some are baskets, some are set prices, and somewhere within all of that soup is this tiny little bit of overcharge, to use the tribunal's words. And somehow at the end of the day, BT sets the prices for wholesale broadband line rental at £80.61. That is not approximate or direct causal connection.
It might be the case as simply as, I mean, we've been trying to get our heads around what the difference between legal and factual causation is. And in Stellantis, the issue was legal because there was a question of an actual step taken to mitigate a known loss. That's why it was a legal issue. Here, that doesn't seem to arise. There's a defence of pass on, and there's a question of, first of all, who has the burden of proof, which the Supreme Court decided was on the defendant. And it may be that in a very, very complicated case where you're dealing with tiny little sums, it's very difficult simply to meet that burden and standard of work.
It is indeed.
It's just either they do or they don't.
Well,
And it's very difficult when you've got small sums masked by ultra complicated cost compilation methods. Maybe as simple as that.
My lord, yes, and I foreshadowed in my opening the submission I am going to make, which is whatever the position is on the law, the majority findings of the tribunal on the facts are unassailable. So indeed, it is our submission that the argument about the law doesn't matter. Mr. Beard needs it because of the evaluative nature of the factual exercise.
I mean, so far as we can see, the legal causation is either when something is just plainly too remote, it's just not proximate enough. It may or may not be this sort of case. Whether it's an intervening cause, a novus actus, whether there was mitigation, factually, or there should reasonably have been mitigation. Those seem to be the four categories of legal causation, and everything else is just a question of fact.
Yes. But then
but MasterCard was looking at duties to mitigate and how people might have mitigated, which is why I think legal came into the rubric.
Yes, but my lord, I don't dissent from that at all, but in your lordship's taxonomy, which I was foolish enough not to write down, one of the points that you made was that
too remote.
Remoteness might arise. I think I've just been assisted by my junior, Mr. Sepchi.
Remoteness, intervening cause, like a novus actus, and then in mitigation either did mitigate, so they just didn't focus on facts, or should reasonably have mitigated, so it's a failure of a duty to mitigate.
Absolutely, and it's really the first of those heads that's an issue in this case, which is about remoteness of how the increase might arise down a convoluted value chain. And that is a fact-sensitive question in itself, but it's Mr. Beard who has to demonstrate there's something inherently wrong with the tribunal's approach to the law. But even if he's right about that, I will be submitting it just makes no difference to the findings of fact. With that, may I take you to what the tribunal actually said about the law, as that will be a fresh terrain for you after yesterday's submissions. And it starts at page 225 of the decision, using the bundle numbering. Actually, it doesn't start there, it's just, this is the useful part. And you'll see at paragraph 178, 5 lines from the bottom, Mr. Beard submitted as a result of Sainsbury's, there is no issue of legal causation. So the tribunal was faced with exactly the point that's raised before your lordships. And then, you'll see, I will take this as quickly as I can, rather than just reading it all out, but it is important. At page 226, there's the tribunal summarises parts of the Supreme Court's judgment in Sainsbury's. The all-important paragraph 215 is dealt with specifically later, I should say. Then it comes to Sainsbury's itself, and at 184, it quotes from the tribunal's judgment in Sainsbury, and you will see at a glance that the tribunal in this case has added emphasis to the causation requirement as articulated in that case. Pass-on defence is only concerned with identifiable increase in prices by a firm to its customers. The increase in price must be causally connected with the overcharge, and demonstrably so. And then over the page is the rather controversial 4845, which is about the requirement to identify a class of claimant. And Mr. Beard obviously debated this with my Lord Justice Flo yesterday about what was left of this after the Court of Appeal had looked at it. And in my respectful submission, the CAT correctly explains the position in 185, 186 and 188, where it says at 185, at 338, the Court of Appeal said, although it was not necessary for the purposes of the appeal to decide the question, this was not an essential condition for establishing pass-on. So this tribunal did not treat it as such. And then at 186, importantly, the Court of Appeal did not interfere with, and indeed seemed to endorse, the test for causation at 4844, that there must be identifiable increases causally connected. And then there were references in the Court of Appeal to sufficiently close causal connection. And then at 188, the Court of Appeal was clearly and rightly reluctant to stray into areas of policy rather than existing law. As a result, it seems to us the Court of Appeal has not ruled out the possibility that 4845 of Sainsbury was not a separate requirement, but was part of the overarching legal test for causation. In order to establish the requisite causal connection, it may be necessary for a defendant to identify who has suffered the loss in order to prove the claimant has not actually lost the full extent of the overcharge. And that, in my respectful submission, is unimpeachable as an assessment of the impact of your Lordship's judgment in Sainsbury's. Then, over the page, it quotes from the Supreme Court, where the Supreme Court articulated its famous categories. And at 192, I've foreshadowed this already, it says in the third line, of more importance is the Supreme Court's suggestion that relevant pass-on will only arise in categories 3 and 4, which are not distinguished. Now, from there, it goes on to deal with the famous paragraph 215, which is at page 199, where, of course, as you can see, they've quoted 215, and the emphasis on arising out of the transaction you see there at the bottom of the page is, of course, original.
In the original,
yeah. And then at 201, I'm actually now circling back to where we were. It goes to the important observations about the test for causation made in the May 2021 judgment. And the CAT says at 35 of the quoted passage, it cannot be enough for a defendant to plead a claimant's business's input costs as a whole were not increased, or that as part of the claimant's business ordinary financial operations and control processes, its overall expenses were balanced against sales so that profits were not reduced. There must be something more to create a proximate causative link between the overcharge and a reduction in other input costs to constitute mitigation. Then it refers to the Supreme Court and the underlined words. And then I've already shown you the bottom of paragraph 36, legally causally connected in a direct manner. And then it says, it appears that DAF accepted the need for a causal connection. And reading from that paragraph halfway down, Mr. Beard put in the course of argument, one does need to have a factual evidence that it was the putative rise in prices of the product that is said to be affected that feed into and are causative of, materially causative of the fall in the prices because this is type 3. And then the CAT continued to identify the sort of evidence that would be required to satisfy the test for pleading. So this picks up a point Mr. Beard was making yesterday, that this case and Stellantis are about pleading amendment. But it's important to see why they are relevant. At 42, in our judgment, before a purely general plea of mitigation through business cost reduction can be pleaded in the way DAF seeks permission, there must be something identifiable in the facts of the particular case that gives rise to a prima facie inference that may well be a direct causative link. And that's the same issue that we're grappling with. For us, it's not whether there's a prima facie inference, it's whether the defendant can discharge the burden of proof at all. And then in the emphasised section, what is sufficient to give rise to such an inference will vary from case to case, but it may be found in facts such as a claimant's knowledge of the nature and amount of the overcharge, such that it is inherently likely that a claimant would seek to address it. The gross amount of the overcharge is a proportion of relevant expenditure. The higher the proportion, the more likely it is some step would have been taken to mitigate. The relative ease with which the business could reduce certain costs, and that of course bears on type 3. And then 43, what is needed is some plausible factual foundation for the application of the broad economic theory in the way required to satisfy the British Westinghouse test that's relied on, and for there being a causative connection. And then the CAT says, well, the issues of knowledge and size of overcharge were further addressed in paragraph 44, and I've taken you to the emphasised parts, or at least part of them. Unlike in Sainsbury, here, where the overcharge was not only covert but tiny, it is inherently unlikely it would have been specifically addressed, but rather fed into the overall expenditure. As DAF accepts, the general principle all costs and inputs are fed into planning is insufficient to establish the necessary causative connection. And then we come to your Lordship's judgment in Stellantis, where I've already shown you paragraph 205. And then 206 is my Lord Justice Green's judgment, again talking about the nature of the myth and distinguishing it in the Stellantis case, which was, if I recall, about ball bearings rather than myth. It's plainly relevant by the time of the Sainsbury's case. The issue of myth, passed on generally, had been live in the industry for many years, as had the compatibility of the myth with competition rules. The first EU proceedings were in the early 90s. There was nothing secret about the imposition of a myth. It was transparent, known charge. It was recognised industry practice that acquiring banks passed it on to retailers. All of this was clearly relevant to the burden facing a defendant in this sector seeking to raise a realistic case of mitigation. The myth was a systemic and troublesome cost that any major retailer would inevitably have had to confront. The facts therefore contrast with those of a typical secret price-fixing cartel. Absolutely, this was a type 3 case. Absolutely, this was about mending the pleadings. But it was about what a prima facie case might look like. And then we can move on to paragraph 213, please, on page 240, where eventually we get to, well, actually, it's just worth noting in passing 212 is where the CAT deals with and distinguishes the myth umbrella judgment that Mr. Beard relied on. And you can see the reasons around the first hole punch. The myth umbrella judgment was heavily influenced by the fact that the ultimate customers, the credit card holders in that case, were bringing their own claims in respect to the overcharge. Indeed, the CAT was principally concerned with effective case management of all claims before it. So that's where the myth umbrella judgment came from. And of course, the clue is in the name. It was another case about myth. So in our respectful submission, of no assistance whatsoever here. And then at 213 to 216, the tribunal addresses the Supreme Court's approach in Sainsbury's and explains the approach it is going to take. And I think I have to concede that the tribunal also looks like it's found this passage quite difficult. But firstly, it starts with the passage from my Lord Justice Green in Stellantis. The facts of the present case contrast with the facts of Sainsbury's. The disputed charge was transparent and retailers had well-established categories for countering it, which were known to include all the methods pleaded in the current case, including offsetting. Mitigation by these strategies was an entrenched and established part of business as usual. The Supreme Court described the issue of causation in the sector as straightforward. And that's indeed the submission I made earlier in answer to my Lord Justice Flo's question. Yeah. And then at 215, the CAT says the Supreme Court's judgment has been taken out of context. It needs to be read with what came before and after. Sorry, that sentence, I should say, not the judgment. And then it said that in that, and then picking up really in the last 4 lines, in that case, the factual question was whether it had recovered from others. In other words, as my Lord Justice Green suggested in Stellantis, it dealt with that particular factual scenario.
Sorry, I missed that reference.
Sorry, my Lord, it's paragraph 215,
Yes.
and I went to the last 4 or 5 lines.
Yeah, I see, yes.
And then the CAT synthesises these cases and says at 216, as was said in Stellantis, the defendant must demonstrate a legal and proximate causal connection between the overcharge and the act of mitigation. Or as the CAT said in May 2021, there must be a direct causative link between the overcharge and, in that category 3 case, reduction in costs. It is insufficient, as was admitted by Mr. Beard at that hearing, merely to allege the claimants were seeking to recover their costs. We do not think, therefore, that the Supreme Court was suggesting otherwise in saying legal causation is straightforward. In that case, it is still necessary for the defendant to prove a sufficient causal connection.
I think that just goes back to a point I made yesterday. I read 215 of the Supreme Court as reciting facts found by the CAT
Yes.
on the evidence in its judgment, not stating general principles, just saying these were the facts
Yes.
as found, the 4 options. There was an evidential base. I remember going back and checking the CAT, and there was variable evidential base. Nonetheless, those were the categories found by the CAT. And the Supreme Court were just saying, well, that's the factual
Indeed.
matrix for the case.
It sounds like an ambitious submission to say the Supreme Court's judgment should be confined to its facts. And I would certainly not go that far, but this context is very fact sensitive.
I think I read 215 as that's what the Supreme Court itself was saying, because it says these were the facts, findings, and it gives the paragraph numbers of the CAT judgment.
Yes, I respectfully adopt that, my lord. And then if I may now just, I'm nearly finished with this because we're quite close to the end of the tribunal's unanimous view on the law. At 219, we are concerned with a category 4 case, which appears to be a more recognisable case of pass-on, because in this category, the cost overcharge has a clear possibility to affect the buyer's incentives when it comes to decide how to set prices for downstream outputs that rely on the input that is subject to the overcharge. But as categories 3 and 4 were both dealt with together in the same way in Sainsbury's, one would expect the same test to be applicable. Merely because a firm seeks to recover its costs and make a profit cannot be sufficient to prove the overcharge has been transferred. Well, with respect, evidently so.
Yeah, well, that's your 90 and 91 example.
Yeah. Exactly. And we agree with the CAT in the May 2021 judgment. There are 2 particular factors which are, in our view, applicable to category 3 and 4, and they are knowledge of the nature and amount of overcharge, such they would seek to address it, the size of the overcharge as a proportion, and then picking up the last 2 lines of that paragraph. Both factors were endorsed by the Court of Appeal in Stellantis, see quoted above. But then very importantly, 222, we agree these are not necessary requirements. But if they are present, a defendant would be far more likely to be able to prove the claimant was seeking to address the overcharge by taking mitigating action. In other words, they are indicia of mitigation. And then at 223...
Well, that's really saying no more, is it? We're going back to the point I made a moment ago. If you know that you've got the myth, then you can deal with it and pass it on. And if you've got some piece of correspondence that shows that's what you did, then evidentially that's going to be pretty straightforward. But if in fact this is all sort of secret cartel stuff, and there is an increase, a very slight increase in the cost of your trucks,
down in the bottom of your 17 billion cost base.
17 billion costs overall, then that's really much more problematic.
Well, that's exactly our submission, my lord. And then it's paragraph 223, where the tribunal synthesises its unanimous view of the law. And this is where Mr. Beard really has to find an error, and in my respectful submission, he just cannot. We consider the DAF must prove there was a direct and proximate causative link between the overcharge and any increase in prices by the claimants. That means there must be something more than reliance on the usual planning and budgetary processes into which the overcharge was input and at some point prices increased. We think there is substance in the point made in the CAT and Sainsbury's as the identification of persons to whom the overcharge has been passed as being a relevant factor. The process is more properly one of identifying the persons who have suffered loss by paying the overcharge and therefore should be compensated. And then if we turn over the page, we have the famous 4 factors, but it's worth looking at them to see how they are characterised. This is paragraph 228. By way of summary, in relation, on the legal test for causation in relation to pass-on, we respectfully conclude that DAF must prove a direct and proximate causative link. It is not enough for DAF to say all costs, including increases in costs, are fed into the claimants or their regulators' business planning and budgetary processes. There must be something more specific than that. And there are a number of potentially relevant factors, including not exhaustive, not mandatory, knowledge, relative size, relationship or association between the products, whether there are identifiable claims. This is not an exhaustive list of factors, but they do seem to us to be the most relevant ones to this case. That's the issue. That's the unanimous view of the tribunal on the law. In my respectful submission, there is no conceivable error in any of that. Where we are left is faced with that, we have DAF's argument, which is in substance that none of those factors matter. All they have to do is meet a case of factual causation, and if their forensic accountant, Mr. Bazant, can trace tiny sums through from trucks to stamps, their defence succeeds. Now, Mr. Beard says...
Delaying you just one moment longer, what do you take criterion 1 to mean?
Well, my lord, we've just been ventilating the way the knowledge requirement was explained in the various cases.
So as you put your case, does it mean knowledge of the price, or does it mean knowledge of impropriety in the setting of the price, or something more than that?
Nothing to do with impropriety. I accept that a secret cartel is never going to be known, and for once I agree with Mr. Beard's observation yesterday that the last thing you'd be worrying about would be pass-on if you uncovered it.
So does it simply mean knowledge of the price?
Knowledge of the troublesome charge, that there is this additional element. Of course you know about trucks. You know you are paying for trucks. Somewhere deep in some spreadsheet there are some trucks. But like the myth, if you know about it, you're much more likely to do something about it.
So sorry, this is what I haven't quite understood. You don't have to know about the impropriety. Obviously you know about the price.
Yes.
But it means something more than just knowing about the price. So what more does it mean?
Well, the way it was put, if I may, by Mr. Justice Roth, on page 243, paragraph 220 in the first bullet point. Actually, this is the tribunal's summary of what Mr. Justice Roth said, and we can look at that as well as what Mr. Justice Roth said himself, because we have both. The claimant's knowledge of the nature and amount of the overcharge such they would seek to address it. Now, by nature doesn't mean the illegality. I take it. I don't read that to mean the illegality. But so
it's the impugned cost component within the MIF. There was an argument whether the MIF was lawful or unlawful,
Indeed.
or any portion of it. People knew there was a MIF, and they were then addressing it. So it is the impugned cost component, not necessarily illegal.
No.
And the critical words are such that they would seek to address it.
Indeed.
Can I just follow that up for a moment longer? The such that they would seek to address it seems to go to the size point.
Well, not necessarily. I mean, it's likely that the larger it is, the more they'd be concerned. But of course, it's relative size in any event.
So what can matter other than size in terms of knowledge? What else might you know that or not know that would bear on whether you were going to address it?
At the risk of being tiresome, I'm going to say, firstly, that's going to be fact sensitive, and secondly, that the myth provides a very useful contrast. So you have this industry-wide known troublesome charge in my Lord Justice Green's terms. The myth is appreciable, and the industry is concerned to pass it on. That's different from not being aware that any kind of overcharge has been applied. All you know is the truck cost £37,000, or more likely that you spent 125 million on transport in 2017.
And that I follow, but that seems to go to a size point. I'm just trying to understand what knowledge could refer to. I mean, you plainly it refers to knowledge of the cost, but you're going to know the cost. can't particularly see that you have to know any particular component of the
Well,
cost.
the impugned element, to use my lord's formulation, is the overcharge. You don't know it's an overcharge, but it's an increase of 5% against the counterfactual universe. Now this is an important point too, that the price of trucks may have been going up or down during the cartel in nominal terms. So the price of trucks might be falling if the price of steel collapsed during the global financial crisis, say. To use a realistic example. So you may know that your truck is actually £35,000 this year rather than £37 last year. You still don't know there's an inflated element in there.
But this bit I don't follow. I'm quite follow you. You have to know the cost, otherwise you can't react to
Of course.
it. But that you're going to know. So what is it also that it could be relevant to know? It's not, you don't have to know that it's an overcharge.
No.
You don't have to know how much is being overcharged, because obviously you don't have to know there's an overcharge at all. I can't quite see what else you could know.
I'm going to gratefully adopt my Lord Justice Green's formulation. It's the impugned element.
So how do you know which is the impugned element?
But the whole point is you can't. That's why this is so difficult.
This assumes that you did, rather like you know about the myth. So you know that there's some, let's say, don't appreciate this is illegal, but the truck manufacturers have put on a tax of some description. So whereas your truck previously, or let's say it represents 5% of the overall price, whatever the overall price is.
Well, let's say delivery charge, my lord. That might be.
I rather like my lord. I'm struggling with why it matters.
Well, let me try. Let me
reason
try.
why
one more time.
you know that the cost of your truck's gone up by 5% since last year. What does it matter that you know, you can identify that increase in cost of 5% is attributable to the tax that I've identified by the manufacturer?
If your tax, let's say a delivery charge, which might be a real world example, if the truck manufacturers suddenly start applying a delivery charge of 5%, then the business is an opportunity to say, well, hang on a minute, all of a sudden we've got this new cost that the truck manufacturers are sticking on us. We're going to have to recover that somewhere. You can actually have a conversation about it. If in fact we're talking about overcharge, as I made the point to my Lord Justice Newey a moment ago, it may or may not even be going up in real terms, but in fact buried in there is an additional impugned element which later comes to light, and but by then you've had no chance to actually address it.
Is it any more, just looking at paragraph 222 again, and trying to work out what the CAT thought of it. They agreed with Mr. Beard that knowledge was not a necessary requirement, and then they state a conditional: if they are present, a defendant will be far more likely to be able to prove the claimant was seeking to arrest. So where there's knowledge, there may be a high probability of establishing pass-on. And I suppose it's implicit where there is no knowledge, there might not be.
Yes, it's
So I
fascinating.
suppose going back to your example,
Yeah,
where the price of the truck has gone down in the global financial crisis from 37 to 35,000. So you say, well, nobody's going to bother doing anything to pass on anything because there's nothing to pass on. But if you knew that in both years you had been being charged a 5% tax, and you were going to continue being charged that 5% tax for the foreseeable future, right, like the myth,
yeah.
then you might very well try to pass on that cost, even though overall your costs have come down.
Well, exactly, my lord. And the CAT does not say this is a necessary requirement. It says it is an indicia, and it is an indicia that is absent.
I suspect they implicitly say, since it isn't relevant, it's less easy to establish pass-on. Where knowledge exists, it's much easier to establish pass-on. That's why they put in the conditional if they're present. Then it's far more likely to be able to prove pass-on.
Well,
Yeah.
my lord, yes. Well, that's the unanimous view of the tribunal. Sorry, can I, if I can assist
I
further?
don't think you can really, Mr.
I just put it on what's been said. I mean, I quite follow any business is going to worry about what its costs are.
Yeah.
can't particularly, if they don't know that they're going to worry about what they are rather than what they are caused by, if they have no control over the elements that cause the costs.
Well, the only thing I think I can try and offer by way of risk of reiteration is that one mustn't lose sight of the fact that what we're trying to decide is whether prices were caused to be higher by the overcharge element than in the counterfactual. That's the question. And as my Lord Justice Green says, if what's staring you in the face is some new charge, or my Lord Justice Flo's tax or delivery charge, it's going to be easier to show that in the factual as compared to the counterfactual you increased your prices. When it's a totally opaque slice of the cost, it's less easy to show. Not necessary, but less easy.
I don't think it's worth very long on this, but I mean, suppose somebody introduced a delivery charge, then the business might think, well, I had better think now about imposing a delivery charge on my customers. Then it might be quite straightforward. But normally, presumably, a business looks at what costs it has and then looks at what prices it's going to charge and doesn't ask itself why any particular input costs this amount.
Well, absolutely, my lord, and that's where DAF has the burden of showing that the prices were actually caused to be higher because of this overcharge. That's their burden, and as I took time earlier to establish, mere cost recovery isn't enough.
And that I absolutely follow, because your aim to achieve cost recovery won't necessarily result in any particular increase in price.
Indeed. Well, I
That's
can't.
the point. I mean, that last point ties in with the tipping analysis, doesn't it, in relation to BT?
Yes.
You've got a whole series of tiny little incremental increases, but somewhere along the line, one of them has tipped it over the precipice and led to an increase in the downstream price. And I mean, that seems to me to be just a sort of variation, if you like, on the point where everybody's always trying to recover their costs and make a profit, which isn't enough.
It isn't enough, my lord. Well, against that background of the unanimous view of the law, I was going to turn, if I may.
Well, I mean, the critical point you make here, sorry to come back to it again, is that you say, well, twice in this section of the judgment, never mind the detail, at 223 and 228, the CAT summarise what the principles, the legal principles are of, as it were, of legal causation. And there simply isn't an error of law there at all.
That's really it. The submission is as short as that. I was going to just show you at 361 what the tribunal actually did with these four factors, because this too in my submission is unimpeachable. And with respect, notwithstanding my Lord Justice Newey's reservations, there is still no error of law here.
Yep, 361.
361, please. And this is after the CAT has been through, I already showed you some of the text about why cost recovery is not enough.
What paragraph?
Page 361, thank you, and paragraph 572. And what the tribunal says is, as we've already said, in relation to the four factors, and those are in the preceding pages, none of them are present in this case. The absence of knowledge, together with the tiny size of the overcharge, means there was obviously no specific decision to increase prices in response to the increase in costs, nor is there any direct association between trucks and the products sold, even though an element is properly attributable to each product. And even if it can be shown there was an increase in prices because of an increase in costs, it will be impossible to identify which prices in relation to which specific product actually increased. And that's because of points we'll see when we look at the charge controls. There are basket controls and so forth. Therefore, we will find it difficult. We find it difficult to see how there can be sufficiently identifiable purchasers. In the circumstances, we do not think DAF can satisfy the legal test for causation, which requires a direct and proximate cause. Even if, as a matter of forensic accountancy, DAF is able to show the minuscule overcharge can be traced through the series of internal steps, judgments and regulatory intervention, price setting, the absence of the four factors mean it is too remote. While the four factors are not themselves decisive or necessary, we find that in a situation where none are present, the evidence of factual causation needs to be that much stronger. we will still examine the evidence and the expert opinions to see if it is strong enough to overcome the absence of the relevant factors. So it takes the non-exhaustive factors, it says none of them are present, but then it says we will go further. And there was criticism yesterday of the language at 573, that much stronger. And in my respectful submission, the gist of this passage is perfectly clear, even if that word is itself open to a question. And I was going to show the court just a very short passage of a judgment about the level of granularity with which one should examine such judgments. If you just bear with me a moment, I've just momentarily lost the reference. Ah yes, it's Authorities Bundle 3, page, tab 31.
Tab 31.
Oh, I'm sorry, that is a wrong reference. Forgive me, let me just find it and then.
It is tab 31.
Tab 31.
Is it Milburn?
Volume 4, yes it is, thank you. It's volume 4, tab 31. And this is stating a very obvious proposition, but it is, in my respectful submission, an answer to quite a lot of what we heard yesterday. Because tab 31, the case is about something completely irrelevant, and the passage is at page 1663. Where Lord Justice Stuart Smith says, it is necessary to read the reasoning of the judge fairly, in context, and with a view to understanding what they meant, rather than sedulously picking and criticising individual words or phrases. And that's obviously, in a sense, a trite point, but I do respectfully submit that the criticism of this passage falls fairly into that category. The gist of what the cat is saying here is both clear, lawful and rational.
Yeah.
And very much the same point can be made about the argument, which is really my fourth head of submissions, about Mr. Beard's specific criticisms of the cat's factual analysis. And you'll recall from yesterday that the point he really developed was the cat had supposedly made an error in respect of the counterfactual. That was the error, that they'd somehow posited the wrong counterfactual. And the alleged error was supposedly committed in the first instance by Mr. Harvey, although we don't think it was. And it's telling that DAF has not actually put in a single page of Mr. Harvey's evidence to show how, if at all, it was supposedly material to his analysis. But this draws inspiration from observations of Mr. Ridyard, and I'd like to show you the way that DAF itself captures the point in its skeleton argument, which is in bundle C6, bundle C, tab 6, page 78. Paragraph 93. What's said in the third line is by starting with the actual price control and asking whether the regulator would change the level of that control if it was told that input costs were slightly higher or lower, it is easy to conclude the regulator would use its regulatory judgment to airbrush out the change. However, by comparing two scenarios in which the input costs are slightly different at the outset, but the regulatory process otherwise runs in the same way, it becomes clear that regulatory judgment is common to both. The only relevant question is whether in the scenario where input costs do include the overcharge is likely to have been reimbursed by the regulator. Well, the last part is simply erroneous because it avoids the obligation of causation. It makes it sound as if mere cost recovery is sufficient, which plainly is not for reasons we've talked about. But the error is supposedly some sort of linear approach where you have the factual and then you're told about the overcharge and the regulator has to ask itself, well, would I do something slightly differently? But none of the reasoning of the tribunal exposes any thinking of that kind at all. It just asks entirely properly whether or not the overcharge caused an increase. or if you like, whether prices would have been lower in its absence. And one sees that throughout the judgment. But what I would also like to do is just show you the ruling of the CAT on permission to appeal.
Yeah.
And this is in volume C, tab 13. And this is a unanimous ruling. And if we could look please under tab 13 at page 125, you'll see the tribunal reject the very argument that your lordships have been entertaining. Where it says, in the third line, DAF goes on to suggest the majority asked the
Sorry,
wrong
which
question.
paragraph?
I'm so sorry, 11. Page 125, paragraph 11. DAF goes on to suggest the majority asked the wrong question for the purpose of assessing causation. But this is a challenge to the majority's evaluative judgment as to the expert and factual evidence, upon which an appeal court would exercise a substantial appellant restraint in deciding whether the judgment was wrong. Well, I respectfully adopt that. But then this is important for present purposes. Furthermore, the majority was testing, as was the minority, whether the claimant's prices would have been lower in the counterfactual without the overcharge. So the unanimous view of the tribunal is that neither the majority nor the minority made the error that is alleged by Mr. Beard. And indeed, one simply cannot find the error on the face of the judgment, so it's unsurprising that this is what they thought. And just to show you one example of this language that is really, which echoes this permission to appeal ruling, could we please turn back to the judgment now, paragraph 3, page 392. And this is actually the conclusion paragraph on both law and fact. 688. We have rejected DAF's case on SPO in relation to both Royal Mail and BT for all periods and lines of business. We have found on the balance of probabilities, DAF has not established on the facts that the prices charged to the claimant's customers would have been lower in the counterfactual absent the overcharge. We have also been clear as a matter of law, we do not consider there to be the necessary proximate and direct causal link between the overcharge and the downstream prices. So that is the, in my respectful submission, unimpeachable formulation of the role of the counterfactual. And even though Mr. Ridyard was the origin of the criticism of Mr. Harvey's approach, neither the majority nor the minority thinks that either of them used that approach in consideration of this claim. And my lords, if that's a convenient moment, I was then going to run relatively briefly, I should say, through the particular charge controls that Mr. Beard opened yesterday.
Very well.
Guys.
That's the same part to Iveco and Man. So he wanted us to sign the draft dismissal order, then return it to Man and Iveco. And this is the email. This is looks fine, right? This is yeah. And then after call number the Iveco warranty or
Who was that? So she was Vanessa,
Vanessa and
I just do she Vanessa, she got Vanessa or
oh,
I'm saying
Sheila.
Commissioner,
Oh, okay. Oh, okay. Can I just put my name there or is that okay? Yeah.
Yeah.
Just right. I think he wants us to send this back, right? No.
what is that?
Okay. And then
And then you've got the decide.
HSF send the order together with the draft order. But I assume they will
Yeah. Might change your subject to second, do you?
Yeah, I was wondering because
Yeah, well, they would do
when I
it.
spoke to Coral, my director knowledge was that it's the same thing GPA. Yeah. Thank you.
Yeah. Yeah.
So many times when you're standing on absolute best, I would like to be the short separate to Chancellor's modes.
It's James.
Guys.
Thank you, my lord. I was going to now just turn to the two price controls that Mr. Beard addressed you on,
Yeah.
and then the jackpot model that applied to OpenReach. So the two price controls concern Royal Mail, and they're Postcom PC2 and PC3. And we can start, please, on, so sorry, let me check this reference is right. Page 366. Now, it's just useful perhaps to just focus on how this price control works, as explained in 596. The vast majority of Royal Mail's products remain subject to price regulation during this period. Postcom implemented glide path controls in the form of RPI-X or POX, Tariff Basket Control. And what that means is the PO is a percentage of immediate price increase that's allowed, and then the X is a sort of percentage efficiency factor. And in modelling that price increase, the regulator will use projected costs, revenues, inflation assumptions, volumes assumptions, all sorts of things that go into it, and then adds an efficiency challenge. And instead of applying prices or maximum prices to individual products, there is a fairly complicated so-called basket control, where the products within the basket can move within a certain range. So it's not saying for, say, second-class stamps, the maximum price is 47 pence. That's just an...
If it's, for example, overall, the total cost of stamps
yes,
cannot be more than...
yes, so we must be careful, because I really don't have the facts at my fingertips about what these baskets really contain.
I'm just trying
But using it illustratively...
not holding you to anything
No,
evidential,
of course.
I'm just trying to understand the point.
No.
There are a number of, not just first-class stamps and second-class stamps, they're all stamps for abroad and so on.
Yes,
so you say, well, there's a basket. The overall cost of stamps cannot be more than X.
Yes, and in fact, the way it's put...
How the Royal Mail sort of divvy that up was up to them. But.
Yeah, exactly so, my lord. And the way it's expressed is, of course, in 597, it's the percentages would be applied to the weighted average of prices in the basket. So to put it another way, if one goes up and another one goes down, then the weighted average will be maintained. What we see is that at 597, what Postcom actually did was apply an immediate 3% increase and an X of 1%. So, if you like, in whole numbers of percentages. And then there were a little bit more detail. Royal Mail's scope to increase average prices of individual products was subject to subcaps, which prevented it from increasing prices by more than 2.5% above the level implied by the level of the price control. So there couldn't be a few things rocketing up within the basket. And then at 599, we see in my respectful submission, stark fact that the revenue during this period was £17.8 billion, price-controlled revenue, whereas the estimated overcharge was £8 million, although this would approximately be halved now by reference to our findings on overcharge percentage. On any view, that is a tiny amount. But Mr. Bazan concluded Postcom's decision on the level of the price cap, whether by PO or X, would likely have been different in the counterfactual without the overcharge. He came to that conclusion for two principal reasons, because Postcom would want to maintain the headroom figure of 21 million, and because of the underlying relationship between costs and prices. In other words, more costs means higher prices.
Yeah.
Mr. Harvey said it was highly unlikely there was SPO on the general ground that Postcom took into account a range of evidence in order to exercise its regulatory judgment. But more particularly, it allowed additional revenues of £170 million per year to fund Royal Mail's modernisation programme, something Royal Mail had been asking for since 2001. This was a good example of broad regulatory judgment. And then at 601, the Tribunal's judgment captures something important. In relation to the 170 million requested by Royal Mail, Postcom was originally minded to allow it in the form of PO3. In other words, that was what would deliver this sum that Royal Mail had specifically asked for. But then it was going to apply an X of 2.5, which would match the forecast inflation. So prices would, in fact, be stationary. So this was a specific lump sum that Royal Mail had been after. And then at a late stage, it decided to change the efficiency challenge, represented by the X, to 1, because of the unusual level of uncertainty surrounding two key determinants of the forecast, namely the realisable level of its cost savings given its renewal plan and its likely future levels of business volume given market developments. And the market developments during this period are what's sometimes called e-substitution, because letters are out and emails are coming in. And then after setting out 3 different options for PO and X, it decided on 3% and 1% respectively, taking into account customers' desire to see a reasonably smooth profile of prices over time and avoid prices going up in 1 year only to come down in the following year, or vice versa. Postcom considered this would best achieve the discharge of its duties in setting Royal Mail's second price control. Well, Mr. Bazan accepted that this shows the exercise of regulatory judgment at the very end of the process, while he still maintained that a different set of costs at the outset, i.e. without the overcharge, would have led to a different PO or X percentages. But we think his analysis fails adequately to account for the overarching regulatory judgment that ultimately determines the price cap. In other words, would it really make a difference in the counterfactual to the 3%, which reflects 170 million that Royal Mail had specifically asked for?
The essence of the point is this, that a bit of 606, isn't it? This is a vast pool of costs in which a tiny sum goes in, and it's impossible, they say, to identify into which of Royal Mail's products the overcharge was passed on, and therefore to whom the loss was transferred. I mean, that's their ultimate conclusion. This is so vast, so complicated. You can't take a small sum and you just can't take a small sum and track it through. Whether that was their evaluative judgment of the evidence.
My lord, yes.
That's really 605 and 606.
Yes, and there's more detail in there as well. I invite the tribunal, the court, to read it at its leisure. But my Lord Justice Green has encapsulated the submission precisely.
Okay.
And exactly the same thing can be said.
It's an evidence point. It's not really a legal point. This is just a point on.
But Mr. Beard was desperately trying to dress this up as a legal point, precisely for the reasons in what your lordship has just said. And without a legal point to, as he would put it, colour all of this, it's appeal proof in practice. But there is no legal point here, and nothing in this reasoning discloses any confusion about the correct counterfactual. And you'll see that, just to pick out one more point from 606 that my lord has gone to, if one goes to about the 6th line of it, deciding exactly how to price individual products requires a substantial degree of commercial judgment, and imprecision is inherent in the process. Far from it being a mechanical exercise that an increase in a tiny amount of cost will inevitably feed through to the price cap, the price setting for each product is much more complicated and involves judgment both commercial and regulatory, as well as inherent uncertainty and imprecision. It would be impossible to identify into which of Royal Mail's products the overcharge was passed on and therefore to whom the loss was transferred.
That logic on PC2 is the same logic they apply to PC3, although for slightly different evidential reasons.
It is, and I take the hint not to bother to develop it because it
just
goes to
before you
exactly the
move
same
on,
point.
we've seen that P0 was whatever it was, 2.5, and X was 1.
P0 was 3.
3, sorry.
That's okay.
It's obviously, well, one can't exclude the possibility that you were at a tipping point, as Mr. Beard suggested. It's obviously inherently very unlikely that this increase in costs could cause you to go from 3 to 4 or whatever. It would seem on the face of it inherently unlikely that it would cause you to go from 3 to 3.1, even a 1 decimal point change. And how many decimal points might a regulator deal?
Well, there actually is an answer to that very unusually, PC3 goes to 2 decimal points. But I think that's the high watermark. But the judgment explains that it did this for what was called sculpting reasons, where it actually started out with a larger PO and then reduced it and adjusted the RPIX accordingly. And that's how it got to 2 decimal points.
Yes, I see.
So that is in fact the answer to my lord's question.
And then just going off to tangent very briefly, I saw back at 557 that it referred to Royal Mail having one of Royal Mail's million price points. Does it really have a million price points?
It does. I will take instructions because I can't quite remember why that is correct.
At any rate, it has an awful lot of price points.
Yes, it's because there are a lot of different products at potentially different weights, I think is the reason. Yes, I'm getting nods. It's not suggesting it's a million products.
No, it's still a million price points, which is
A lot of price points. Well, I will, as it were, heed the tenor of Lord Justice Green's observation.
I mean, when you stand back from this, the end conclusion, both the PC2 and PC3, is that on the evidence, it's insufficient to say whether the cost would have been any different on the other side of the balance. And then they explain in the preceding paragraphs leading to that conclusion what gets them there. So, as drafted, this is a finding of fact. And unless the legal test is incorrect, then it's a pure question of evaluation. But even the legal test, they simply say they cannot, there's no proven nexus.
Indeed. So, in fact, the legal test is not really a feature of this reasoning at all.
And in relation to PC3, I think they say it's a question of its factual conclusion.
It is.
In 617, not legal causation.
In a sense, the tribunal's judgment is not factual, never mind legal. You never get past the factual to even worry about whether it's proximate enough to satisfy the legal test. So there's no, even if Mr. Beard is right in all his submissions about the law, they just don't affect this factual analysis at all.
Well, there isn't an infection.
Or
And
there's
he
no-
tried to suggest yesterday that if they got the law wrong, then that infected their factual analysis of the evidence.
Exactly.
Difficult to see how that.
It's just not there, my lord. It's just not there. May I turn to the position with BT, which focused on the probability analysis, and it's actually useful to start, if I may, at page 383, where there was one specific, in fact there were two specific charge controls that applied to OpenReach that were looked at by the tribunal in some detail. I mean, paradoxically, it was the claimants that put them before the court rather than DAF. But you'll see just at 657 that the problem they faced was that the OpenReach charge control in question that we looked at, the total value of the overcharge was £5,000 out of £106 million in costs. That was the overcharge that they were trying to trace through the price control.
Sorry, paragraph.
Sorry, 657.
Sorry. I was looking at the wrong paragraph.
And then the CAT's conclusion was, this really is picking up the point that was just put to me, 658. DAF bears the burden of proof showing the very small overcharge made a difference. The charge controls are not set down to the fullest possible level of cost granularity. They may be set in whole pounds or pence. An RPI X may be set to a whole number or one decimal place, meaning it cannot capture a tiny cost increase. That is why the probability analysis came to the fore in Mr. Bazant's argument. I'm going to talk about that now. Now, yesterday Mr. Beard said, well, how can the tribunal disparage this just because it's complicated expert evidence? It didn't disparage it because of that, but what it noted in the next paragraph is that this is what Mr. Bazant was driven to because he couldn't show in an orthodox way that the overcharge caused the prices to be set differently. I'd like to show the court the reasoning, if I may. 659. The probability analysis is concerned with the rounding of the value of X in the glide path control. Mr. Bazant's argument is that at some point, the rounding would tip over into the next level, at which stage the overcharge, however small, would likely to be recovered. On the face of it, the fact that Mr. Bazant is driven to having to make this sort of argument seems to demonstrate DAF's inability to trace the overcharge through into downstream prices, and therefore to be a long way from the proximity required to satisfy the legal or factual test for causation, but nevertheless, we look at it. And then I'd take you now, if I may, to 644, because this also explains why the probability analysis was relied upon. 664, so sorry.
664.
Page 385. However, DAF has pursued this argument because it does not know if it actually happened. As Mr. Bazant accepted, he did not have access to the detailed models in order to test how big the unrounded value of X was and how close the charge control was to the rounding step. In other words, whether it really was near the tipping point. This meant the probability analysis was being used to predict what might have happened in the past. And as was discussed at the hearing, is effectively a jackpot theory in which the rounding could have taken place at any time in relation to any product, producing an unknown amount that may cover some or all of the overcharge. And then after a quotation from the questioning by the tribunal, 665, the logic of Mr. Bazant's argument is that over the 25-year period being considered, if one price control tipped because of the overcharge, that jackpot could be applied to other products under other time periods under different charge controls. During that period, some products will have been introduced, others made obsolete. Trucks will have been purchased and disposed of. Yet, on Mr. Bazant's approach, a jackpot in 2018 in fibre broadband could be said to constitute SPO of truck costs incurred in respect of retail line rental in 1997, or vice versa. It also matters greatly which charge control tips. And just to skim rather than read it all out down to the last 3 lines, the jackpot may be as little as £100. Mr. Bazant accepted this. It does matter which product, as you know, and as we have discussed, we do not have the models to identify this. So the question now is whether the conclusion of the tribunal on the next page is either erroneous in law or irrational in fact. In our view, this is wholly inadequate evidence upon which to prove there has been SPO, one might say at all, let alone 100% SPO in relation to the overcharge attributed to Openreach. DAF cannot show this actually happened. Even if it is more likely than not that one or more charge control tipped, DAF cannot show which one did and when it happened. It is impossible to identify which downstream customers may have ended up paying the overcharge, or who may have a claim against DAF. It cannot be said that BT has recovered the overcharge from others, so factual causation has not been established. Even if BT might have hit the jackpot at some point, that cannot represent the recovery of the overcharge, and we do not think that could have been the intention of Ofcom. In other words, the truck comes along, tips the jackpot on some price control some point in the last 25 years, so there's a rounding up. But why is that rounding up a form of passing on of the overcharge? That's the point, rather than just a kind of windfall on marketing or something of the kind. And of course, all of this analysis proceeds on a probability analysis that assumed Mr. Harvey's overcharge was correct, whereas of course in reality, the tribunal found it was about the real level was about half. So I hesitate to do the maths, but the probabilities would evidently be lower. Now, in my respectful submission, that is evidently an evaluative judgment that was open to the tribunal that discloses no error of law whatsoever. On the contrary, it is, in my respectful submission, manifestly correct. And then at 668, we think this also can't amount to sufficient proximity. But that, of course, doesn't matter at all, given that the claim has failed on the facts. Now, that was all I was going to say about the factual analysis. And I was just going to speak very briefly, if I may, about Mr. Ridyard, while reiterating my submission that I do not need to show it is erroneous. All I need to satisfy you is that the majority's judgment was lawful. But we do respectfully submit there is an error here. And to pick it up, if we turn to please, page 403, it's really encapsulated in paragraph 713. Where Mr. Ridyard says, in the third, he talks firstly about naive regulation, which obviously is not the case here. And then he says, if truck case costs are part of the total costs of operating a service, the regulator would, in naive regulation, set price controls to allow the claimants to recover their costs. And so by definition, it follows it would have allowed them to pass through the overcharge. And then I can see no reason why the fact that the overcharge was small in relation to costs or revenues would in any way alter that conclusion. Because that's obviously right if the regulation is so naive that the price of the stamp will become £47 and 0.0014p. But of course that's not the case, and Mr. Ridyard is not suggesting it's the case. But in the real world price controls that we are looking at, his analysis really is encapsulated at the bottom of paragraph 716 on page 405. The last 5 lines, the pass-on mechanism on which Mr. Bazant relies, which I find broadly convincing, is that the overcharge would find its way into the claimant's reasonably incurred costs, and the regulatory process is more likely than not to reflect the overcharge elements of these costs when setting the price control. And then even in that business that's not subject to regulation, against the last 3 lines again, costs are often a strong driver of prices. Well, with respect, the problem with this analysis is that it proceeds at a high level of generality. And that expressed at a high level of generality, it looks unobjectionable, but it doesn't grapple with the specific issue that the majority did about whether this tiny unknown overcharge in fact caused prices to be higher. So we do respectfully say, if we needed to, that the dissent isn't right. And then I'll just make one final observation about the principle of effectiveness. Mr. Ridyard recognised there was a difficulty because he said any downstream claim would be excessively difficult or impossible because, of course, it was empirically hopeless, in his words, or virtually impossible to quantify the claim. And we've seen from the unanimous judgment on the facts that it was relevant there were no identifiable downstream purchasers. But what Mr. Ridyard has done here is posit an impossible claim, in his words, that nobody would be able to bring. And so we do say at this point, the principle of effectiveness does apply because DAF is trying to rely on this impossible to quantify non-existent downstream claim as a way to defeat the claim by the actual direct purchasers, which is before the court.
One might be a little bit nervous about going there given the way in which some of the downstream claims are being framed at the moment for small sums.
Indeed, but we are past, I make no submissions about limitation. I merely observe we're well past 6 years since the decision was published. My lords, those are my submissions on supply pass-on, which leaves me with ground 3, bodies. It's 20 to 4. I'm confident of getting this done this afternoon and may even leave some time for Mr. Lusk. Now this appeal, part of the appeal, largely proceeds by mischaracterising the tribunal's reasoning and indeed a selective reading of the decision that we had this morning, and indeed DAF's own evidence. Now just to remind the court, it's an issue in respect of Royal Mail. Royal Mail bought trucks including bodies from DAF, not just what DAF calls naked trucks, and DAF itself supplied and manufactured bodies to other customers. It supplied bodies to Morrison's, but it also manufactured bodies at its UK plant for 4 years of the cartel from 2007. And this was the point which Mr. Beard said I was keen to be his conscience on, and I am, because it matters. And if you'd like to see that, I can show you in the evidence, or I can just give you the reference. It's Mr. Ashworth, and it's S751, paragraphs 216 to 218. Now the issue is whether the overcharge percentage should be applied to the entire purchase. But to be clear, what we're talking about is bodies that are supplied by DAF. They're on the DAF invoice, if you like. And this is not some body supplied by some third party by a different route. And it's true that some of them are manufactured by others, but just so on a truck, for example, the tyres might be manufactured by Michelin. We say that really is no answer. Now, if we turn to the decision where the arguments are set out, please, we can find that at page 331. Sorry, can that be right? Yes, it can. 331.
Yeah.
And it says at paragraph 468 that our main point was that bodies are within the scope of the settlement decision. And DAF seems to have accepted that until August 2021, when it changed its mind and it decided that the infringement was limited to what it thereafter called the naked truck. And that was a surprising development because we had a several-year process ordered by Mr. Justice Roth before that of trying to identify the effective price of the truck. Now, the short point we made, which is partly encapsulated in the judgment, is that the decision specifically excludes some things but not bodies. And if we could take the decision up now, there's just a number of points I want to make on it. It's in S4. And if we could please turn to page 17. And if we could take it up, please, recital 3, first of all. Page 17. And the first thing is important, recital 3. The facts, as outlined in this decision, have been accepted by, among others, DAF. And then 5 is the definitional paragraph that Mr. Beard took you to. And there's the point that my Lord made this morning about how you weigh a truck. But importantly, it just says trucks, other than 2 types of exclusion. Footnote 5, excluding trucks for military use. And then the last sentence, the case does not concern after sales, other services and warranties, the sale of used trucks, or any other goods and services. Well, I confess, I've been in this litigation for about 7 years, and today was the first time I heard an argument that bodies might be other services. And that did take us by surprise, but it's quite a stretch to say that if this is otherwise part of the truck, it might other goods, it might be other goods. Now, because this is a settlement decision, the facts have been accepted in exchange for a discount on the fine. And of course, all of those entering into this settlement must have appreciated the prospect of large numbers of follow-on claims, even if not quite the 17,000 that DAF was facing at least last year. And as my Lord Justice Green says as well, the exact scope of the, if you like, product in question goes to the value of sales, which goes to the level of the fine. And we made the point, which is reflected in the judgment, that if the manufacturers had thought bodies were not part of the cartel, then surely they would not have agreed to this. And now, in his skeleton argument, Mr. Beard said, well, DAF could not dictate the terms of the decision. And there was a similar submission this morning. But it is important to appreciate the degree to which DAF was actually in control of this process. And to make that good, I want to show you just some of the process part of the decision about settlement. Could we please turn to page 21 in the decision, in the bundle numbering?
Where does it go to say you can't control the process? You get a settlement, you agree the definition. If on the face of the record, and that's something we have to decide, if on the face of the record trucks includes bodies, then that's it.
That's it. Well, I'm really meeting Mr. Beard's point, where he says, well, look, we couldn't dictate what was in the decision, as if it was a non-settled process case.
Well, you can not settle and fight, and there's obviously an incentive not to do that.
A big one in this case. So I agree, in my respectful submission, it's not particularly a helpful point from Mr. Beard, but the point I'm really underlining here, if I may.
The other point, if you wanted to dispute something in a decision, and you wanted to say it wasn't binding for some exceptional reason, you prove facts that demonstrate it was wrong.
Indeed. That's the point. It was open to DAF to come along and say to the decision. If we just pick up what actually happened here, at recital 32, matters begin when the Commission carries out what are usually called dawn raids. Then at 37, it initiated proceedings. Then at 39, it sent the parties a statement of objections and gave them access to the file. And the statement of objections, as I'm sure all members of the court know, is essentially a detailed set of allegations. And then in paragraph 40, all of the addressees approached the Commission informally and asked to continue under the settlement procedure. So they see what the Commission's allegations are. And then at 43, MAN, DAF, Daimler, Volvo and Iveco submitted formal requests to settle and the settlement submission of each addressee contained an acknowledgement in clear and unequivocal terms of the addressee's liability for the infringement, summarily described as regards object, the main facts, their legal qualification, etc. They didn't have to do any of that. And as my Lord Justice Green says, at any point one can pull out of settlement negotiations and choose to fight, or make submissions, which we cannot be privy to, about whether or not the main facts are right. Instead, they've affirmed that they are right. Now, the other point we can take from the decision is that it makes clear that the collusion extended to truck options. And we had some evidence from the bar this morning that that cannot possibly mean bodies. But if we look at the terms of it, it's really quite general. So if we please go to page 20, recital 28. With regard to initial gross price lists, all the addressees except Iveco applied a gross price list across the EEA. And then the last sentence, the EEA price list contained prices of all medium and heavy truck models, as well as all factory fitted options the relevant manufacturer provided. Then recital 46 talks about configurators, which unfortunately we don't know what they contain, as DAF successfully resisted our application for disclosure. But again, if you look in the fourth and fifth line, truck configurators contain the detailed gross prices for all models and options. And sorry, there is another one the judgment refers to, forgive me, I've lost the reference. 56. Later meetings became more formalised, spreadsheets. The future gross price information exchanged referred to either the basic truck models or trucks and the available options. Now, Mr. Beard said something to the effect of there's no evidence of any supply of any bodies by any other manufacturer. But we do in fact have in the supplementary bundle two documents from the file, by way of examples. And can I please show you these? It's S number 1 is a DAF price list.
So
Sorry, S tab 1.
tab 1 of the bundle.
Supplementary bundle,
Tab 1.
tab 1, page 1.
Okay.
And you'll see it really from the very first few lines. But what's given there are prices of different trucks with different body types. You can see that if you look at the 1, 2, 3, third line, price, that FALF45 is model number, 08T, box body. And the next row, a different price, curtain cider, then sweeper, then tipper. And skimming, you can see those words elsewhere. Then under tab 2 is a document from a different manufacturer, which again contains information about body types. And we can see that very clearly, for example, on page 7 of the internal numbering of this document. Oh no, it is bundle numbering, so sorry.
Yeah.
And in the last 4 lines there, different types of tipper bodies attracting different prices for that particular manufacturer. And in fact, we can tell from the Commission File Index that these documents were exchanged with other cartels. And if you want to see that explained, it's in our closing, which is supplementary 23, page 307, paragraph 365. Now, the other thing that's really important here is that DAF itself...
Let's make sure I understand that. So this information was exchanged. We can see from this information, we can at least draw an inference that bodies were included in the price. And the Commission analyses the exchanged information as leading to an cartelisation of gross price.
Well, I'm not even going quite that far, my lord. I'm just saying there's exchange of information about bodies as a form of options in these particular price lists that were exchanged as part of the cartel. That's all I'm saying. And one thing that we might have lost sight of slightly is that the decision doesn't just refer to gross price lists, it's pricing and gross price increases. And I can just remind you of that, if I may, which is in S4 is the decision, and I know someone behind me will, it's actually in the operative part of the decision. It's paragraph 41.
Can I just again, I'm just trying to get the facts straight. The expression or the articulation of the exchange of information includes possible truck configurations. So that would be a truck and might include a body, at least on the information we've seen.
Yeah.
That was the information which was the subject of the infringement.
Yeah.
It could be truck which includes body, or it could be truck in a configuration which includes a body.
Yeah.
So on that basis, the exchange of information included bodies and is therefore the subject of the infringement.
Well, that is essentially the argument, my lord. And I was just going to
The
try.
only question we've got to ask is whether the tribunal, I mean, let's assume for the sake of argument that Mr. Beard is right, and further disclosure would show that. We simply have to decide whether on the basis of the decision, of the judgment, it was a proper analysis of the decision,
Absolutely.
given the evidence that was before the tribunal, plainly lacking in many respects.
Well, that's exactly right, my lord. Absolutely. And this
You
is my
don't
response.
decide the underlying question of fact.
No, you don't. Absolutely not. But I'm at least showing you where
Yeah, no, I
the
understand.
underpinning is. And I was just going to show you two things from the decision that are helpful here in my submission. If we go to S4, page 41, it's Article 1, and it's important that the decision is about collusion on pricing and gross price increases. So it's not just gross prices on their own, as if that's just one thing. But then, to make good my point, I want to just remind you again of wording I read you a moment ago in recital 28. The last sentence says, the EEA price list contained the prices of all medium and heavy truck models, as well as all factory-fitted options. Factory-fitted options. Well, what I would like to do now is go to Mr. Ashworth's witness statement for DAF, which is also in bundle S, under tab 7 this time, and ask you please to turn to page 56. And this is talking, so obviously we have DAF manufacturing its own bodies. They are, in a sense, axiomatically factory fitted because they're manufactured in the factory. But talking about Royal Mail and Morrison's, in paragraph 60, Mr. Beard read this. He talks about how, Mr. Ashworth talks about 6 lines down, in addition to liaising with bodybuilders, we had to purchase certain items, Bod Ford liaised. And then it's the next sentence. We would then fit these items onto the truck in our factory. Well, fitted in the factory is the same as factory fitted. So then if we go to see what the tribunal said about this, this is really all argument that's summarised in the decision. We then get, we go to please page 332 in core bundle again, tab 17. We get, firstly at the bottom of 472, Mr. Ashworth gave unchallenged evidence that DAF UK negotiated with body and tail lift manufacturers and then charged Royal Mail at cost or a very small margin. And Mr. Beard took you to that, and as the judgment says, it wasn't challenged. And it wasn't challenged because well, I'll show you why, rather than A and B. I'll just explain why. Because what the tribunal said in 473 is absolutely right. We consider that DAF's failure to provide any evidence as to how the cartel operated, and particularly in this respect, as to how it affected pricing for the whole truck, including bodies and other options, leaves us in the dark on this question. The most natural approach to take here, given the absence of that evidence, is to consider truck bodies equivalent to the other extras. And why do they say that? Well, because that evidence of Mr. Ashworth you see referred to there is not in any way evidence about how the cartel operated. And Mr. Ashworth, in fact, explained he had no knowledge of the cartel at all. So, and the reference for that, I don't need to take you there, it's in the judgment, it's paragraph 18 and paragraph 162. So Mr. Ashworth knew nothing about the cartel, so he couldn't illuminate us as to how the cartel might have influenced the pricing of a truck that included a body. But he did say one thing that was very important, which also we didn't challenge. So if we forgive me for going back to Mr. Ashworth, under S tab 7, page 52, paragraph 48. With all upgrades from the basic specification, DAF would attempt to charge the customer more. Ultimately though, especially with Royal Mail, the negotiation would always come down to the price the customer was willing to pay for the whole truck. In other words, you put the options on, you put the body in, and then you haggle with Royal Mail. And it's that process of price negotiation through which the cartel was at least plausibly transmitted. This is a significant part of the judgment we haven't had to open today, and I'm just going to give you one example, if I may. So if we turn to page 204 of the judgment, where various of this evidence was set out, I'll just give you one sample.
Page 200.
204, and obviously I commend this entire section to the court, but we really needn't go through it today. I've read out rather a lot of this judgment, I'm afraid. 123.2, in a memo from the M&S director at DAF NV, Kerry McDonough, who was admitted to be a participant in the cartel, to the managing directors of sales units, such as Mr. Ashworth, in January 2004, a list price increase of 3% was announced, and it was emphasised this will not be a cosmetic exercise, and we expect this list price increase to produce a real increase in net revenues. And this was one of the ways that we argued successfully that DAF was seeking to put pressure on people like Mr. Ashworth to get higher prices. And indeed, on the previous page, he says that it worked on him. And if you look at paragraph 120, it says, as has been explained above, the exchange of gross list price information, and in particular proposed list price increases, formed a major part of the infringement. Mr. Ashworth frankly admitted that in the case of direct customers such as the claimants, a very good rule of thumb was DAF UK would normally achieve about half of a list price increase. And it says at the bottom of the paragraph, Mr. Beard sought to downplay his evidence, saying the data didn't bear it out, but we think Mr. Ashworth's evidence is significant. And then towards the end of the paragraph, important in showing list price increases were thought to drive transaction prices up and used by sales team in their negotiation. So what you have with Royal Mail is a negotiation over the whole truck in the shadow of pressure from DAF NV, the cartelist, to increase prices, using gross list prices, which were one of the core elements in the cartel. So then if we go back to the tribunal's reasoning, it is in my respectful submission unimpeachable. Go back to 473. We've seen how the decision apparently talks about factory fitted extras, options. We've seen how truck bodies are options fitted in a factory. We've seen that although Mr. Ashworth viewed the way this element was priced was simply a very small margin, we've also seen there is a negotiation on the entire truck in the shadow of the cartel. And that's why the tribunal is fully entitled to say DAF's failure to provide any evidence as to how the cartel operated, as to how the cartel affected the pricing for the whole truck, leaves us in the dark. The most natural approach is to apply the language of the decision, and at the bottom of the paragraph, we think DAF should be upheld to what it signed in the settlement decision, and this did not clearly exclude bodies.
It's the point that I made this morning, isn't it?
It is.
I mean, what he says in 472 is all very well, and of course he was innocent of any participation in the cartel. So no doubt it's right that they'd add on the 50 quid or whatever it was, but it simply doesn't address the fact that in relation to the entire truck, because of the cartel, they've actually negotiated another £100 or another £200 or whatever it is. Probably thousands rather than.
My lord, that's exactly it. Those are my submissions on ground 3.
Right.
It's just past 4 o'clock. Mr. Last tells me he needs about 40 minutes to do finance.
How much time do you need in reply, Mr. Bird, in broad terms?
Well, if we were to start tomorrow and Mr. Luss was to take 40 minutes, I don't think I would require full 2 hours. No, I was thinking more like half an hour, 40 minutes.
So if we were to break now,
Yeah, that would be fine.
because again, it's been quite a long day.
And we wouldn't be jeopardising you being the last out of the building.
Sorry?
We wouldn't be jeopardising you being out the last out of the building.
Touche, I think is what to say to that. Okay, let's break until 10:30 tomorrow morning.
All rise.